Hi everyone, and welcome to the launch of the CEVAW WLSA report on First Nations women's experiences with the family law system. My name is Heather Douglas and I'm a professor at the Melbourne Law School and a Deputy Director of CEVAW and the co-author of the report we're launching today. Before we begin, I want to acknowledge the Wurundjeri people of the Kulin Nation on whose unceded land I'm dialing in from, and I want to pay my respects to elders past and present. And I also want to pay my respects to any First Nations people joining us in the room today. I'm very proud also to be dialing in from a place, Victoria, where we have NAM, where we have treaty. So that's a really hopeful time, I think, here. I'm going to introduce our speakers in a moment, but just to note before I do so that the speakers will speak for about 35 minutes. And if you can put some chat in the chat function, we'll be able to get to your questions towards the end of the webinar. Eleanor Rosenman is with us today, and she is the chair of the Women's Legal Services Australia, and that's the peak body for specialist women's legal services in every jurisdiction across Australia. She's also the CEO of Women's Legal Centre in the ACT. Women's Legal Services Australia are also obviously a partner with CEVAW on this project. Eleanor's going to lead the Q&A and she'll close today's session. So to our two wonderful speakers who are joining us to talk about the report today. First of all, I want to introduce Dr. Samantha O'Donnell. Sam is a non-Indigenous research fellow here at the Melbourne Law School. She's also an affiliate of CEVAW and obviously the co-author of today's report. Sam completed her PhD here at the University of Melbourne only in 2025, so a very recent graduate. Sam's approach to research is very much informed by her experience as a lawyer working across both community and government sectors. Sam has also published her research in leading criminological and legal academic journals, but she's also published in more accessible formats. And indeed, you can find these reports, obviously, but also she's done a fact sheet on our CEVAW website, which you can check out after the webinar. I also want to introduce Stephanie Monk. Stephanie Monk is a Kanarakan and Warramunga person and a recognised traditional owner of the Finnis River and the Walgett Land Trusts in the Northern Territory. I hope I got that right, Steph. She commenced as the Women's Legal Service WA Principal Legal Officer in mid-2021. Prior to this, Stephanie was the Principal Legal Officer at Aboriginal Family Legal Services. She's also been Senior Lawyer at the Department of the Attorney General and Justice and Solicitor for the Northern Territory in their Litigation Division. I welcome you both and look forward to hearing from you.
Thank you.
Thanks so much, Heather. It's really fantastic to be launching this important report, and I'd also like to acknowledge that I'm joining today from Wurundjeri country and acknowledge any First Nations colleagues joining today, including the fantastic Stephanie, who you'll be hearing from in a moment. So as Heather mentioned, this report is based on a partnership project that was conducted with WLSA, who really identified the focus on First Nations women and their experiences with the family law system as a priority area in terms of research that's needed on the ground and that would be of benefit to the community. And so the focus is particularly important in light of what we know about First Nations women and families, where First Nations women face significantly higher risk of family violence than non-First Nations women and are at greater risk of having their children removed by state-based child protection agencies. So for some, the family law jurisdiction is seen as a system that could help protect against child removal and operate protectively for victim survivors of family violence. And so it's in this context that I think it's really critical to know, well, is this system working for First Nations women? And if not, what would work for First Nations women? So what this report does is reflect in research the knowledge of women's legal services and the practitioners in those services about why First Nations women use or don't use the family law system, and then the huge amount of barriers as well that we'll come to that they face when engaging with this system. So in terms of what we did in this project, there are two main ways that we gathered this information, so two methods that underpin this report. The first thing that we did is conduct focus groups and interviews with professionals working within women's legal services who provide that support to First Nations women who are victim survivors of family violence. And so Heather and myself, we conducted these with 30 participants in total. We spoke to lawyers, social workers, Aboriginal engagement and access workers, managers and financial counsellors. And 8 of these participants, so 27%, identified as First Nations. And then we also took a national focus. So we were lucky enough to speak to people from every state and territory in Australia as well. The second thing that we did is include 6 anonymised case studies from First Nations women who were clients of Women's Legal Services, and these were provided with the client's prior consent. And it's through these case studies that we really aim to bring First Nations women's lived experiences and stories into the report based on, how are they engaging with this system. A really critical and central part of the project was the guidance that we received from our First Nations reference group, which included First Nations women lawyers and managers from Women's Legal Services, as well as the principal solicitors of Warringah and First Nations Women's Legal Service Queensland. And so it was this reference group that provided guidance on all elements of the project. And then we also developed the recommendations in consultation with this reference group, as well as WLSA and Women's Legal Services. I'd personally like to thank both WLSA, everyone in our reference group, and Heather for all the time and insights that were provided throughout this project, as well as all of the participants who gave up their time to participate in a focus group or interview. It's been wonderful working with everyone, and this report really wouldn't have been possible without this collective effort. So I'll now move on to providing an overview of the key findings. But before I do, I just want to make a note on the terminology that we use in the report. So when we use the term the family court, we include the range of family courts, so Divisions 1 and 2 of the Federal Circuit and Family Court of Australia, as well as the Family Court of Western Australia, which has its own family law jurisdiction that Stephanie might comment on as we go along. But our focus was also broader than just this court context. And when we use the term the family law system, we include the family court, but also post-separation services like mediation and counselling, as well as government-funded legal and non-legal supports. So back to the findings, there were 4 key themes that we structure the report around. The first is First Nations women's engagements with the family law system. The second is barriers First Nations women face to accessibility and safety. The third is system responses. And the last theme is potential improvements identified by the participants. And then you should be able to see these themes and the report as well in the chat through that link there. So what I'm going to do is provide a brief overview of each theme and then pass over to Stephanie to provide comment on each theme as well. So starting with the first theme, engagements with the family law system, in our report we really outline when, how and why First Nations women are engaging or not with the family law system and the role of Women's Legal Services in these engagements. I'll start with the legal support that was being provided by Women's Legal Services to First Nations women in this family law context. And what we found is that a lot of the support being provided was actually outside of that litigation or court-based context. So many of the participants supported First Nations clients in that mediation or pre-court space in negotiations and giving advice and information. And when participants did support First Nations women in litigation, it was often when the service was funded to offer representation to First Nations clients in family court matters. And First Nations women having access to First Nations lawyers and cultural support was really critical to this as well. As an example, we had one participant note, and I quote, "It's so important to have mob assisting mob. This is why our program works so well. Yes, we're in a mainstream women's legal centre, but having a program run and led by First Nations women makes a difference." But many participants still noted concerns in relation to First Nations women's safety in the family court, and there were some participants who rarely supported First Nations women in that litigation context, and these participants were often located in remote and regional areas. So this finding really highlights a key concern coming through the report, which was the resourcing constraints faced by Women's Legal Services in terms of providing legal representation to First Nations women in family law matters. And this is a barrier to accessing the system that I'll return to when we consider the next theme. There were also a couple of situations where it was clear that First Nations women had no choice but to engage with the family court, even in light of some of the safety concerns raised. And this first situation was related to grandparents, and family law was seen to come into the picture quite regularly here. So women's legal services often provided support to grandmas to apply for access to their children, or supported First Nations women as respondents to an application brought by commonly it was a paternal grandparent. The second situation that we heard a lot about was recovery orders. And so for those of you who don't know, well, what is a recovery order? It's an urgent application made by the court to have the police intervene and recover a child that's been unilaterally removed by one party, for example, the father. And First Nations women were frequently identified as applicants for these orders. So we heard from participants that seeking the recovery of a child who'd been removed by another parent was one of the most obvious reasons why you would choose to enter into the family court context or go into that context. As a final point on this theme, we also heard from participants that their First Nations clients commonly had other legal issues occurring at the same time as their family law matters. And importantly, First Nations women's experiences of systemic racism and discrimination across these other legal systems, like the criminal legal system or the child protection system, could then play out negatively in their family law matters. And then we also heard of examples where social inequities like systemic food insecurity and overcrowded housing were being weaponised by the other party in a parenting matter, and that there was still this thin understanding in the family law system of the importance of connection to culture for First Nations children. So a really central and overarching finding from this section of the report is that when we explore how First Nations women are engaging with the family law system, it becomes clear that their engagements are shaped by systemic and structural barriers, many of which we'll come to in the next section as well. But before we do, I'll now pass over to Stephanie to provide comment on this theme. Thanks so much.
Thank you, Samantha. Well, we all know that the past focus on First Nations women's experience in the Australian legal system has mainly been in the criminal law, child protection and family violence protection orders jurisdictions. And we know from the statistics of the Federal Court and Family Court of Australia report of 2023 to 2024 that 7% of family court final order applications include a First Nations litigant. But largely the family court is underutilised by First Nations women because, as already pointed out, child protection system is the issue for First Nations people first and foremost. We know that First Nations children make up 44.5% of children in out-of-home care nationally. And so engaging with family law systems by First Nations families that may be reduced by these rates because you can't bring a family court application while care and protection of children proceedings are on foot. And we also know that nearly 45% of First Nations children under 15 years old live in single-parent households, and that family violence presented in 83% of parenting proceedings in the family courts during 2023-2024. Bearing in mind, I must stress that WA does not keep statistics on the number of Indigenous people or First Nations people accessing family court services. We know that First Nations women are at a higher risk of family violence than for non-First Nations women, and we also must change the dialogue a bit around perpetrators of family violence of First Nations women, because there is this perception that, you know, it's always First Nations men committing the violence, but there's many First Nations women who have non-First Nations partners who perpetrate family violence on them. Like I said, non-existent statistics in WA because their annual reports, Family Court WA annual reports do not report on the demographics of court users, despite you have to tick the Aboriginal and Torres Strait Islander boxes on family court forms. So I assume that ticking those boxes is a process for the court to have an understanding that they might have to consider First Nations cultural considerations when making orders in parenting matters. I think that's all I probably got to say on that at this juncture. We could probably move on to theme 2.
Definitely. Thanks, Stephanie. And I think, you've raised some really important issues around child protection, which I think moves us nicely onto this second theme, which is the barriers that First Nations women face to accessing the family law system. And so, that first barrier that comes through the report and that came through the focus groups and interviews really resoundingly was how child protection impacts First Nations women's engagements with this system. So we heard that there was a general distrust of legal systems more broadly due to fears of child removal, shaped by both historical and contemporary experiences. And the distrust of the family law system was really compounded by child protection's active involvement in the family court. So this involvement was often through co-location programs, which I won't go into in detail, but which we detail in the report. And what this co-location looked like also varied between jurisdictions, so there wasn't a consistent approach either. As Stephanie mentioned, First Nations women are also excluded from accessing the family court if child protection is involved, because once there's that child protection order, you can't then apply to the family court unless you get special leave to do so. And in the circumstances where First Nations women could apply in the family court, so where there wasn't already that child protection order in place, the family court was generally viewed as a better alternative than child protection. And while it wasn't viewed as a safe or perfect option, it was seen to be more flexible and adaptable than child protection, which I think is an important note there. The second barrier to First Nations women's safety identified in the report is the lack of cultural knowledge and competency across the family law system. And then a key thing that participants commented on as well is that interrelatedness between physical and cultural safety. So we were told that First Nations people cannot feel culturally safe in an environment where their physical well-being is at risk or where they fear racism and exclusion. A third barrier was the material barriers impacting First Nations women's ability to access the system. And in the report, we explore a range of these, which related to remoteness, technology, language, and the length of family law proceedings, which commonly carry on for some time. The fourth barrier related to systems abuse and misidentification. And so these were really key issues raised by participants as well. And in relation to systems abuse, this was described as particularly common, to go back to what Stephanie mentioned, when the other parent is non-First Nations, which is often not recognised as much in this space, and because of systemic racism and privilege, is able to get a better outcome in the family law system or trap First Nations women in really lengthy and expensive court proceedings. Misidentification was also raised, and so we know from existing research that First Nations women are disproportionately misidentified as the perpetrator of violence by police. And we really heard that misidentification in civil, the DVO, an intervention order, or criminal proceedings can then really negatively impact First Nations women in their family law matters. So there's often this false history of perpetration that's being brought by the other party into the matter, and it's something that the judge is then forced to weigh up as they're making their decision. The fifth barrier related to family violence. So we heard that family violence impacts how First Nations women can engage with the family law system and their safety when they do engage. And this really reflects as well stats from the Federal Circuit and Family Court of Australia. So in 2023 to 2024, 83% of parenting matters involved allegations of family violence. There is a specialist list in the family court, the EVIT list, and it exists for high-risk cases like those involving family violence. But to go again to Stephanie's point around data, there's no data available on how many First Nations families are being transferred into that list. As a final barrier, we found that accessing legal assistance was really essential to First Nations women accessing the family law system. But we heard that resourcing constraints impacted First Nations women's ability to access appropriate legal help. And this finding is really usefully contextualised, I think, by an analysis of 2023 data from Women's Legal Services, which found that over 52,000 women are being turned away from women's legal services annually due to chronic underfunding. So, Steph, I'll pass back to you for comment on this theme around barriers.
Thanks again, Samantha. Well, you rightly pointed out that, First Nations people generally have a distrust/mistrust of engaging with legal systems and other agency systems, for example, housing. I'll just use that one. We're aware of the systemic racism, bias and discrimination that abounds against First Nations people generally since colonisation. And then in respect of the misidentification that you raised, First Nations women are highly likely to be misidentified as the perpetrator of violence by police when police attending. So we have ineffective police responses when called out to family domestic violence situations, and which then leads to the child protection system, and which can overlap with family law matters. We know that where they do, and if there are proceedings on foot in the family court, that the Department of Child Protection, is often asked by the court to provide a report as to the contact they might have had with any family. In WA, I know that they have co-located services in some states, not in WA. We have a co-location in this respect, that they have an employee from the Department of Child Protection based at the court who will, is in a position to provide a memo to the court when required. That's the only role they play there. There's also the fear of other agencies that support First Nations women, where there might be some mandatory reporting requirements. If there's concerns around child protection issues, then women would be reluctant. Many First Nations women are reluctant to continue to engage or not engage at all with those kinds of services for fear of their children being removed. We know that the family law system must take into account any family violence when making orders in relation to parenting matters. And it's already been said, and it must be said again, that First Nations women who have endured family violence and that who do engage with the family law system, they'll only do it generally because their non-First Nations partner will have made that application. And then there is a perception around that, and this is backed up by research, that a non-First Nations party's version of events is likely to be given more weight in family law proceedings. So my view of that is that First Nations cultural considerations are not taken into account to the depth that they probably should be in child rearing practices, for example. We see it as our community raises our child, not one person or not the nuclear family. And as you pointed out, there's a lack of cultural knowledge and competency across the board in the family law jurisdiction. Cultural safety and security, we all know, impacts anyone's well-being, doesn't matter what culture you're from. But for First Nations people, of course, it's always the ongoing fear of racism and then, of course, exclusion or having their voice excluded. Look, there are suggestions about how we can improve that, but I think that comes a bit later in one of our other themes. So I'll leave it at that.
Thanks, Stephanie. Yeah, exactly. We'll definitely come to some of those improvements and I guess, ways that the system could change to better support First Nations women. But there are also some ways in which the system has already responded. And so in our report, we really, as a third theme, sought to understand how effective are these system responses? And so we focused on the Indigenous list, Indigenous family liaison officers, and then specific legislative amendments as well. So we kind of cover off all those three in the report. Starting with the Indigenous list, it's currently available in 10 family court locations, and participants described this list generally positively in the locations where it existed, but the safety of this list was really seen to be dependent on being led by a culturally safe judicial officer. And really critically, Indigenous lists were seen to be great, but a starting point only that must be accompanied by broader systemic and structural change. So they're not going to overcome all the barriers that we've already mentioned today. We also asked for participants' perspectives on Indigenous family liaison officers, or IFLOs for short. And these are First Nations identified roles, which are based within the family court that provide assistance to First Nations families using the family court. But similarly to the Indigenous list, IFLOs were only located in some jurisdictions. On the whole, IFLOs were described by participants as helpful, informative, responsive and important, but again, it was an issue that they were not available across the board, and so more IFLOs were seen to be needed. But there was also some concerns raised about the nature of the IFLO role, where they see both parties in the matter, which is an issue, particularly in this family violence context, as it could potentially impact the victim's survivor's desire to speak to that support person if that support person is also speaking to the other party who's the perpetrator of violence. So some potential issues with kind of how that role is structured as well. Some of the participants also spoke about the generally expanded cultural considerations in the legislation, so in the Family Law Act, and while these reforms were seen to be useful and the intention behind them positive, there was a sense that the implementation was lacking and that a change in practice is also needed. So that change in kind of, well, how is this being implemented on the ground? And finally, while not a system reform, so to speak, one thing that was resoundingly clear throughout the interviews and focus groups was the importance of access to First Nations-led cultural and legal support within women's legal services. So accessing this kind of support was considered critical to First Nations women's safety when they're engaging with the family law system. So what Aboriginal community-controlled women's legal services or First Nations-led programs within mainstream women's legal services provide is that gender-specific support to First Nations women, as well as choice for First Nations women about what service they want to see, and conflict management in small communities so that there's more than one kind of legal assistance service there as well. So passing back to Stephanie for our comment on these system responses.
Thanks again. Sorry, I'm just scrolling up to my notes and making sure I don't miss any of the points that I want to talk to. Well, we know also, so the family court, I've already said, well, in making parenting orders, they must consider First Nations children and need and right to have continued contact with their culture, their community, their families, their language and or languages. They might speak more than one First Nations language, and of course their country. And on this point, I need to say this. I attended another event the other night, and Denise Kickett gave a monologue on the importance of the Whadjuk people of the Perth area, and it applies to all First Nations people, about our connection to our country and our law and our obligations. They're not separate. You can't separate them. They're combined. You know, our law doesn't sit over there on its own, and our country doesn't sit over there. So everything about us is entwined in our country and with our being, and where we fit into that in that context. So, you know, that's a big ask for modern contemporary Australia to grasp, I know, but it has to be done. So in terms of cultural considerations, because the Family Law Act Section 61F is about the application to Aboriginal and Torres Strait Islander children in terms of having regard to their kinship obligations, our child rearing practices, and of course, I said our culture. The Family Law Act 1975, Section 60C, Section 60CC is how a court determines what is in the best interest of a child generally. But Section 3 of that, subsection 3 of that, it says that the court must consider the child's right to enjoy their Aboriginal and Torres Strait Islander culture by having support, opportunity, encouragement to connect with and maintain their connection with the members of their family and their community, culture, country and language, and to explore the full extent of that culture consistent with the child's age and development level of the child's views, and to develop a positive appreciation of that culture and the likely impact any proposed parenting order under that part will have on those rights. Now, we know that the Act says that. It's a matter, of course, the courts transferring that when making parenting orders. And we will talk a bit later about the issues around perhaps not the judiciary not being well educated, I guess, in a sense that, yeah, they're just not words in an act. They're actual, themes, and we want appropriate responses to them so that parenting orders are culturally appropriate where First Nations children are engaged in this system. In respect of the Indigenous Family Liaison Officers, we don't have that in WA. But in terms of their role, Samantha briefly pointed out that what they can do, but they do attend court hearings or other court events to provide support and explain the process. They do assist with accessing court information and filing of documents. They can connect you to a legal and other community-based service. They do assist with connecting with court-ordered programs. They do talk to communities about family law and the court process. And they can explain practical reasons that may affect what's happening, what the court has asked of you and what you should do. They can visit services, the legal profession community, to talk about the courts and their role. Of course, they can't advocate for you and they cannot give you advice. In respect of what the comment you made, Samantha, about the reluctance of First Nations people not wanting to engage with the IFLO when they see, let's say, because they see them talking to the other party. In a cultural context, great idea, the IFLO, but culturally, we have women's business and men's business, and it's always my view that there needs to be a more cultural approach to this. One AFLO cannot suit that role. There's, we First Nations women particularly already have a mistrust of systems and court processes. And I'm not saying that the IFLO is biased in any way, but it's the perceived maybe partiality if they see the IFLO talking to the other party. With respect to the Indigenous list, again, WA does not have an Indigenous list, although I do sit on a committee with that Justice Robin Cohen chairs, and this is a topic that we discuss, but it's not going anywhere at this stage, but at least it's on the agenda as something for the future for WA. So yeah, we know that the Indigenous lists really affect mainly work across the eastern seaboard, and I know I think there's one list in South Australia and the Northern Territory as well. What are the benefits of having the Indigenous list? Well, it's not as formal as the court process itself, the adversarial type court setup. The judicial officer can decide whether the court can be closed to the public. And of course, we know the presiding judicial officer has discretion to transfer matters to the Indigenous list if it becomes apparent that an applicant, a respondent, or the children or child or children identifies a First Nations person. So there's at least that discretion. In respect to First Nations-led cultural and legal support and women's legal service, I say that is critical, as do many others, including Samantha. And there's, of course, the issue around that, of course, going forward would be, funding for those kinds of supports in women's legal services. I think
thanks,
that's it for me.
Stephanie. Yeah, I'll jump in again for our final theme. So this was really, some of the things that Stephanie's already touched on in terms of that need for funding and elements like that. But the key improvements that were identified by the participants we spoke to, many of these improvements do align with the most recently updated Reconciliation Action Plan from the Federal Circuit and Family Court of Australia, which is good to see and that we refer to in the report. And then we're really hoping that that these recommendations turn into action and are implemented. So many of the suggested improvements were focused on increasing First Nations women's safety when attending the family court. As Stephanie mentioned, the kind of positives around the Indigenous list and IFLOs, and so suggestions were made that despite some of those issues, to expand the Indigenous list to more locations and resource more IFLOs. Suggestions also focused on increasing access to other supports like interpreters for First Nations languages and visual and audio resources in First Nations languages as well. And then there were recommendations to improve court layout and process. So that was often focused on improving safety for victim survivors of family violence in the family court, including in remote and regional areas where there were sometimes different kind of safety configurations there. More broadly, our participants also suggested a number of those suggestions to improve cultural safety and competency, and this included just increasing First Nations representation across all aspects of the family law system, so more First Nations lawyers, mediators, report writers, judicial staff and judges, and then going to that education piece that Stephanie mentioned as well. Suggestions were made to implement education, but really ensure that it's ongoing, it's in-depth, and it relates to both cultural competence and family violence. And so it really moves beyond what is often a ticker box approach to education. There were also calls for increased funding to really ensure that, First Nations-led services and access to culturally safe legal advice and representation. We explicitly refer to these calls in the recommendations as well. As a final point to note, participants also suggested resourcing of First Nations-led mediation, and that's both in court and outside of court as well. So, provided by someone like Relationships Australia at the moment, as well as resourcing for self-determined alternatives to formal legal pathways. So passing back to Stephanie for the final comment on these themes.
Okay. Trying not to repeat what you say, but rather than more comment on the matters that you just raised, Samantha. To increasing safety. Courts are not culturally secure places for anyone, really. But I must say the Family Court of WA is doing its utmost. They have a lot of Aboriginal art displayed around on every level of the court and the federal court jurisdiction over there as well. So, I'm not saying that will increase cultural safety, but it's a familiar thing for Aboriginal people to walk in and see some Aboriginal art on the wall and think, oh, that's great. It's more what goes on in the family court in terms of the processes and the formality. So those kinds of things need looking at. Perhaps a bit more flexibility in where hearings can be conducted. And I'm not suggesting full-on trial hearings, but certainly interim hearings or mentions and that kind of thing. I agree that we need to improve access to the Indigenous list, and the Indigenous Family Liaison Office I've already spoke to about that. And of course that reach has to be expanded into WA at some point in time. Anything is better than nothing, in my view. In WA, we have a specialist protection and care jurisdiction. It's called the Dandu Bidiac. So it's a therapeutic court for First Nations families. So, we're attempting something in that space, and it's a less formal court setting. So let's see if that kind of setting can be expanded into family court at some point. Interpreters, of course, there's always going to be a lack of interpreters. And the other thing to think about interpreters is that a potential conflicts could arise where, an interpreter's been asked. They might be family, they might be extended family connections. So that's always going to be an issue, I see, until more interpreters are trained and taken up to be in that space. And a lack of interpreter, of course, also can delay proceedings, because if there's no interpreter, then proceedings are adjourned to another date. I agree with the audio and visual resources that should be everywhere, but we would understand that there's restrictions, or not so much restrictions, but barriers to that when you think about a rural, remote and very remote areas of Australia. Yeah, again, I mentioned the court layout, so formality abounds, but that needs to be addressed where Aboriginal families are engaging with family law. Certainly we need more First Nations lawyers, but bear in mind, just because a First Nations person studied law doesn't necessarily mean they want to go out and work in any areas of law that impact on their family in the family law space or family violence restraining. A lot of them go off into policy or go and work for mining companies and do other things, heritage law and that kind of thing. So it's not to be an expectation that every First Nation lawyer is going to go out into community and work for communities. Mediators, of course, is always an issue, but we know with the high levels of family violence in First Nations families that, and the requirement of the family court that you must try at least first mediate, that then there's an awful lot of exemptions from having to mediate in that space. And report writers, and until more Aboriginal people, First Nations people become skilled and experts in fields of report writing for courts, single expert witnesses, etc., that's always going to be a restriction. And the costs are high to get a report by a First Nations, expert report writer in that space. And well, where's the money going to come from for First Nations person in that space? And again, judicial staff and judges, of course, they need to have some cultural security competency training, and it should be ongoing. Yeah, I think that's all I had to say to that. Thank you.
Thanks so much, Stephanie. I think we'll now pass over to Eleanor to field some questions and for some closing remarks as well. You're just on mute, Eleanor.
Oh, it's just perpetually 2020 in my life. Thank you very much, Sam, for taking us through the findings of this really important report, and particularly to my colleague Steph for her reflections on those findings as one of the critical members of the reference group and a leader within WLSA as well. It was really fantastic to hear that coverage. There are a number of questions coming in through the chat, and there are some on the Q&A, and then we've really and then there are some also coming through the chat function. So I might just go to those in the Q&A first. The first question, one of the reflections, I guess, that came through, particularly both your observations, was around some really positive reform in terms of thinking about the value and understanding of connection to culture for First Nations children and their families, but also possibly, where there has been lack of real ability and implementation to actually make that a reality. One of the questions in the Q&A that it's related to this is around particularly the lack of cultural capacity in ICLs, and particularly if they're, how First Nations women and kids engaging with the family law system can, what are some systemic changes that could be made to support those, I guess the ICLs building that competency and then making sure it's included in the considerations.
Stephanie, do you want to jump in or do you want me to?
Oh, look, I'm happy to just say this. It just comes back down to having an understanding of First Nations culture, and ICLs don't necessarily have that. And so it comes back to training, not just for the judiciary court staff, but for lawyers, because I know one of the other questions refers to training for lawyers and judges being together. Of course, the more people involved in a training exercise like that, or it just, it opens up the door for different perspectives to be brought to it. Of course, the bench is going to have one view, and a lawyer arguing a case is going to have another view, and the ICL, who's apparently has to have the children's best interests at heart, as does everybody, but they're representing the children's interest in that respect. Of course, they need to have an understanding of First Nations culture and the context of that, because it's complex and cultural context. There's complex cultural context for First Nations people, and I'll draw everyone's attention to the IATSIS map of First Nations Australia. There's so many different boundaries and languages, and yeah, we're all Aboriginal, as we're called generically, but we're not. We're First Nations, and we've got our own cultural context within those boundaries. And no one's going to understand it all overnight, but it's more about people having an open mind and to accept that those complex cultural contexts exist.
Steph, I wonder, if I could ask a follow-up question to that, which is that I think actually, and I refer people to the report on page 25, there's a really beautiful quote from one of the practitioners about some of the cultural value and meaning of a relationship, particularly between a child and their mother within Aboriginal culture. And this struck me as an example of, of understanding that would change potentially, or had the potential to change over time, people's decision makers. Can you, from your experience in practice, give, I guess, the flip side, which is some examples of where you think culture, the value of Aboriginal culture has been well understood by practitioners and how that's changed the outcome for particular families? So whether or not there are practitioners that have been able to put the value of culture before a decision maker and how that might have affected the outcome?
Look, I can't comment on that in the family law space because I don't have experience in that. But certainly in the protection and care space here we do. And that's because we have that Dandy Bidiak court. So there is that requirement in that court that cultural considerations are paramount in making orders relating to children. So I'm just suggesting that, that all of that needs to carry over into the family law jurisdiction.
Yes, I can. And are there examples, I guess, Steph, of where that has happened, where you feel like there's been a better outcome for families? It doesn't have to be in the family law jurisdiction. I'm just wondering if you've seen any good practice or that you could share with us, because I think what comes through really clear from the report is how deeply institutionalised the experience of racism is for First Nations clients and practitioners. But I guess I'm also conscious that that some examples of where we've been able to remedy that try and take a step would be useful.
Yeah, I can't give you a case study because we do so many. It's our core, one of our main, part of our core business here is protection and care of children. All our lawyers, we have cultural security or cultural immersion training regularly. And we're also a trauma-informed practice, which is another issue which we haven't really talked about. And that's the thing about trauma-informed spaces as well. But our lawyers, I know, advocate hard for First Nations children to be returned to their parents. And of course, sometimes they can't always be, and that's, understandable because there's complex risk issues there before the court. And but in terms of children, let me give you an example. I do have an example. She was a grandmother. Again, this is another thing that happens in the family law space. Is often it's the grandparents, because the parents are, they might be caught up in alcohol and drug issues, or they might be incarcerated. So grandparents are left, looking after the children. So they're making these kinds of applications. But I had this one grandmother, and she wasn't a blood grandmother. She was extended family grandmother from these two little children that had been removed from her because it was found that her non-First Nations partner had been sexually interfering with an older child. So they took the two little fellas off her. And we had nearly a 2-year battle getting those children back to her. She got rid of that partner straight away. She took out a restraining order, etc. Issues that were raised in terms of culture for the children because they were with non-white non-Indigenous carers. No disrespect to them, that's just where the children were placed. But the notion that culture for children is taking them to a NAIDOC event or letting them do some dot painting or something is, rather ridiculous in the face of what culture actually means to First Nations children, because it's not just those kinds of things. It's about being with your family, whether that's your blood or your extended family. Anyway, we eventually got that lady back her 2 grandsons, and and that goes on. But it was the court taking notice eventually of the culture of these children and the right for them to be with someone who wasn't their blood relation.
Yeah. So, that capacity across the system, both in terms of legal assistance and decision makers. Steph, did you also have Sam, did you have any reflections on ICLs and particularly anything that came through in the research in relation to ICLs?
Yeah, definitely. It was definitely something that people mentioned as well, the importance of ICLs having that kind of ongoing cultural competency and education, and it not being a one-off thing, but really having that ongoing awareness and knowledge as well. And it also came back to that question with some suggestions around just increasing the representation of First Nations peoples across the system, including in that ICL role. And we also heard that if a First Nations child can't have a ICL who's First Nations as well, really ensuring that they can access that First Nations kind of cultural support as well. So we heard a lot about First Nations engagement and access workers who would provide cultural support to women, but potentially having that access for First Nations children as well.
Yeah, it's a great point. And I mean, I guess related to that and taking in to note Steph's comment, which is, first of all, not assuming that all First Nations legal practitioners or any practitioners in the system are going to want to work in this space. I just wanted to note the recommendation that how critical the representation of First Nations people across the system is. But I also want to acknowledge that the report certainly paints a picture of a system that is profoundly unsafe for First Nations people. And I think that includes First Nations clients, but of course First Nations staff and practitioners are in that system all day, every day, and many of them in our sector also working within a mainstream organisation which has its own limitations. So I'm just wondering if, you know, given all of that, if we've seen any promising processes that support the development of a First Nations workforce in this space, like what are the things that that we've seen work or that might work to make this a more attractive place for these practitioners to work?
I don't know if I have a full answer to that. So Stephanie, you might be better placed. But I think, you know, for some of the First Nations participants that I spoke to, it was about seeing First Nations people in the system as well. So, you know, being able to see First Nations judges, lawyers, and working in those really supportive teams. And, you know, someone kind of explained that, you know, we can kind of guarantee the cultural safety in our team for both us, but also the women that we're working with. But then you can't guarantee that cultural safety in the court. So I think it just goes back to that point around that systemic structural change and, really focusing on that as a whole, noting that some of these more, not smaller reforms, but like the Indigenous list, IFLOs are important steps, but they really can't be the end of the picture.
Steph, what have you seen in your experience?
Well, in WA, our First Nations magistrates and a judge do not preside in the family court. They're in the magistrates court or the district court, largely overseeing criminal matters and protection and care matters. Look, I think it's dangerous to suggest that, you know, that it's going to, you know, we're going to have a flurry of First Nations lawyers wanting to go and work in the family law space, because that's just not going to happen. So for me, it's more about what do we already have? We've already got a number of lawyers, a number of judges, and so on. And it's not to say I don't want to promote the study or the practice of family law to other First Nations up and coming lawyers. Of course I would, but we need to work with what we've got now, because it's going to be a long time coming before we have an all Aboriginal or all First Nations presence in a courtroom in the family court system.
Yeah, I think that's true. And I think certainly what comes through in the report is the need for the system itself to be accountable to First Nations people, not to be relying on First Nations practitioners to provide that accountability. That's an important point, Steph.
Yeah, and I forgot to say this, but I want to say it now, is that, you know, in terms of barriers to First Nations people having access to family law jurisdiction, we know that the barriers to disclosure and support for First Nations people largely stems from, like we said, the distrust and mistrust. But there's also that issue of lateral violence in First Nations communities, because we're talking about, like I said, we're not separate from our community. We're not separate from our country. We belong together, if I can just put it like that. they can be subject to ongoing abuse. There will be retaliation, you know, the lateral violence, like I said, and of course, then again, we get back to that fear of children being removed. So until those kinds of things are addressed, I think we're always going to not really know the full extent. Well, at First Nations women will not be accessing the family court in droves, let me put it that way.
Yeah, and I think Sam's summary about the weaponisation of social inequities and institutional racism is certainly worth drawing attention to as well.
Yeah.
Thank you both very much for those reflections, and to people who provided the questions. I'm sure that you have many more, but it has also fallen to me to close today's seminar. And to do that, I wanted to first acknowledge the First Nations women who actually led this research through the reference group. As Sam mentioned, they're practitioners from across the country, but I did particularly just want to name them in this context. So they include Vanessa Graff, Serena Kenny, Andrea Kylie Saylor, Rachel Martin, Stephanie Monk, Matilda Slater-Phillips, and Lisa McClure. And I just want to thank all the women for the work that they have put into this piece of research over a very long time, and the trust that they've placed in this process. I also wanted to thank CEVAW particularly for the opportunity to partner. And Steph noted a few times actually the paucity of specific research and data in relation to First Nations women's engagement with family law, despite, you know, significant research on intersecting legal issues. So I really want to thank Dr. O'Donnell and Professor Douglas for making, I think, this really important step into documenting and increasing the knowledge in this space, and particularly, I think, the way that that you went about it to gave us an opportunity to make sure that it was that the expertise of the First Nations practitioners and the stories of clients are really here front and centre to inform the development of law and policy and practice. So I wanted to thank you very much for your support, and hopefully it's the case that, you know, that there'll be further engagement and that this will spawn more and more research and interest and change in this issue, because, as I said, it's parts of this, some extraordinarily beautiful comments from the practitioners, and there's some pretty hard realities about the engagement in this jurisdiction. So certainly a lot of change. And I also am happy to pass on the apology of the Attorney General for this event, who has noted the report and is definitely interested in reviewing the findings. So I think that really speaks to how important this project is. So thank you to the people that were involved in doing it. In terms of how to access the report, I think it will be available on the CEVAW website, and there is a QR code that will come up somewhere magically that people can access, use to access and that report. This webinar will also be available on the CEVAW YouTube. So on that note, can I again thank everybody who participated in this research, who's taken the time today to really make the research accessible and alive, and to all of the people who've joined us on the webinar today. Thank you for your interest, and we are really looking forward to continuing this important conversation.